Now, we all know that Section 9 of the Constitution is the Equality Clause. Section 9.2 is the Redress Clause. Section 9, which is the Equality Clause, forbids discrimination on a whole host of grounds. Section 9.2 says there is such a thing as fair discrimination to redress the legacy of the past. But that is not a blunt instrument. Any discrimination that is deemed to be fair has to be proved to be fair. You can't just do anything in the name of redress and claim it is fair discrimination. There's a benchmark that has to be reached to qualify as fair discrimination under Section 9.2. And this Act fails that benchmark test 100%, we believe. And that is the primary constitutional argument that we will be making in court. We have a technical argument as well, which is that this Act should have been tagged under Section 76 of the Constitution because it has such a profound impact on many of the provinces. Now, as you will all know, when a bill that is before Parliament is going to impact provinces, it has to go through the process defined in Section 76 of the Constitution. And that is a different process from a bill that doesn't particularly impact the provinces, which then goes through a Section 75 process. A 76 process is different from a Section 75 process, and one of the primary differences is that it gives a much bigger role to the National Council of Provinces because they represent the provinces, and if the NCOP turns it down, you need a 2/3 majority in Parliament to pass that. So it's a fundamental different process, and we're arguing that it should have been done under Section 76, but that's the technical argument. We also have a substantive and principal argument that I set out to you at the beginning. Now, we had a previous employment equity regime that was passed, I think it was 26 or 27 years ago, and that one allowed companies to set targets to achieve more equity in their workplaces for designated groups, which are people of color, women, and people with disabilities. And they enabled companies themselves to look at their context, to look at the number of people qualified in the specific fields that they might need, to look at their geographical situation, to look at a whole range of factors that impact on your business, and then to set targets, and then to seek to achieve those targets. There were penalties for not achieving the targets, but one of the fundamental ways in which this new Amendment Act goes far further is that it puts extreme penalties on companies for not achieving quotas set by the minister.